Okay, on the record in Wv4 Ldha LLC versus Danian Dibbs, 24-06948. Appearance for the record, please.
Good afternoon, Your Honor. Attorney Samantha Straight, 193 on behalf of the plaintiff.
Your name, sir? Okay, today was the date that was set for a hearing for non-payment of rent. My understanding is that the parties resolved this with a conditional dismissal.
Yes, Your Honor. We have a signed conditional dismissal for the court's review. Certainly, Your Honor. We do show that currently there is past due rent in the amount of $718 with court costs in the amount of $220.27 for a total bill owing of $938.27. This is due to the time period ending of 2/28/2025. Defendant has agreed to pay $200 every month beginning on 2/15/2025 until the balance in 2D is paid in full. Defendant has also agreed to make timely monthly rental payments in addition to the repayment agreement with no personal checks. And if a reinstatement is necessary, the money judgment would be for the total amount of rent due at the time of reinstatement. This is box 4B and box 7 check.
Thank you. Okay, and then Mr. Bibbs, that's complete and accurate as to how you want to proceed in this matter. Okay, sir, you understand that you do have the right in this matter to proceed to trial. You could have demanded a jury trial in this matter. You understood that? Do you want to give your right to a trial? You want to have a trial?
No, I'm all right.
Okay, so you want to give that right up, is that correct? Is that okay? You also have the right to present any defenses to past due rent at the time of that trial. You also have the right to be represented by an attorney today. You've appeared without counsel, correct?
Yes.
And you're waiving your right to have an attorney represent you on this matter. You understand partial performance will not satisfy this conditional dismissal. So you need to do exactly what you said you were going to do in this section here. Otherwise, if you don't, they can request judgment to enter against you without noticing you of any future court date. You understand that? Do you have any questions for the court? You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you've given up, you can return to the court and request to have this agreement set aside. So in counting your 3 business days, Monday doesn't count because it's a holiday, okay? Do you have any questions? Any additional matters for the record?
No, Your Honor.
Okay, we'll get you a copy of this in just a moment. Thank you. No problem. On the record, in the matter of Hometown Properties versus Janine Perell, 24-06949. Appearance, please.
Good afternoon, Your Honor. Robert Ocken, the attorney for the plaintiff.
No one's appeared on behalf of Janine Perell. Default judgment can be entered.
Thank you, Your Honor. I can submit it through my file.
Thank you. On the record, in the matter of Todd Dowd versus Gerald Littlejohn and Kimberly Fish, 4-06938. Appearance, please.
Todd Dowd.
Sorry, 86242 on behalf of the defendants, Your Honor.
Date that was set for a hearing This is for non-payment of rent. My understanding is the parties were not able to come to resolution, correct?
Yes, Your Honor, that is correct.
Okay. So I'm gonna move over, then we can take that extra seat for Mr. Joward for her to have. Mr. Joward, you can take your claim.
Your Honor, no rent has been paid for 6 months. Not 1 cent. There was a judgment from August 21st of 24 for 907.28. That was paid on September 3rd. But no rent, not $1 has been paid for 6 months. I have communicated with the tenants every week or two. I have all the texts, and I brought them for a whole year. Not once have they asked for any repairs. They stopped corresponding back with me in like September, October. But so I have every text, every communication we had.
So it's September, you're saying you were communicating with them and they stopped responding?
That's when they stopped responding. I've been communicating with them every week or two for the past 6 months. What I have printed off is a text that I had between the two of us for the past year. Nothing about any maintenance. When I spoke with the attorney yesterday, he called me and says, oh, you know that the tenants don't have any heat, they're using space heaters. No, I do not know that. That has not been said to me. The house could burn down if they're using space heaters. So that's simply untrue.
They don't have heat, why?
I don't know. That's what the attorney said. Yeah.
Okay, so you were first informed, you're saying yesterday, of the lack of heat in the units.
The day before court, 6 months
Okay.
ago. The last time that the tenants communicated with maintenance was 2 years ago. It was February of 23. So we've had nothing from them. The house is a licensed rental property. I have the ledger here. I have a copy of the text, if the court wants to see them. I have a prepared judgment.
How much is their
Reflecting,
monthly rent?
the monthly rent is $1,300 per month. So the total rent with late fees for the 6 months is $7,900. The court fees $167.28 for a total of $8,067.28. I have the money judgment prorated to today's date as well.
Any other testimony or information at this time?
Not at this time.
Mr. Tyler?
Would you like her to take this one?
I don't need anyone
I mean,
that you
yes,
want to call. You
I
gotta
would
call who
love to
you
call.
want.
I would love to call Ms. Kristen.
Thank you. Can you raise your right hand? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You can have a seat there. I need you to speak up loud and clear because the lady behind you has to be able to take down everything that's being stated on the record, and then I have to be able to hear you over this, okay? Thank you. You can proceed, counsel.
Ms. Kristen. Would you please state your name for the record?
Kimberly Fish.
How do you know the plaintiff?
He's my landlord.
He's your landlord, okay. When did you move to the property over there at Lakewood, in Lansing?
I believe it was 2018.
Okay, and who has lived at that address with you?
Myself, my fiance, my daughter, and my son lived there when we first moved in. Okay, now have their own place.
Okay, so currently it's just you and your partner?
Yes,
Okay, and did you sign a lease?
yes, I did.
Was it a lease for a year, or was it a lease for a month to month?
It was a 12-month lease.
Okay, and what's the arrangement now? Are you guys month to month or still lease?
I haven't signed another lease.
Okay, so it's month to month. What was the agreed upon rental amount? What did you guys agree to?
It was $895 a month.
Okay. And what is the most recent rent you guys have paid?
1,200.
$1,200 a month. I believe the complaint says $1,200 a month as well, does it not?
Yeah.
When was the last time you guys did pay them?
We were in court the last time we went to court, which was in August, I believe. And we had a judgment.
And you guys paid? And from my recollection, it looks like you guys made that payment indeed on September 4th,
Yes.
which you brought current with
Yeah.
that payment. Okay. Did you ever have any discussions with landlord's agent, his son, about the fixes that need to be made over the 9 years, 8, 9 years you guys have lived with the property?
Yes, I have.
Okay, okay. It could have been maybe potentially longer than the 1 year birth. Was there a reason you may have stopped making those connections or reaching out?
Well, when I addressed it to Todd over the phone, he told me I had to contact his son, Brad,
Okay.
in which I did.
And then what happened after you contacted Brad?
He was going to come out. And that was 2 years ago when my grandson was born. And I told him he could still come or he could wait. He said, I can come tomorrow, I'll be free. And he never showed up
What was he coming for?
to fix the furnace.
Okay.
So just to reiterate, you did put Mr. Dowrick on notice about the furnace 2 years ago. He told you his son would contact you. Son contacted you. There was a mishap in maybe trying to get together
Yeah.
to get the fix made, and then it never was in follow-up, correct?
Yeah.
Okay, okay. So are you guys currently still without you?
Yes.
Okay, okay. Have there been any other maintenance issues with the property?
Yes.
Could you name some of them for me?
We had the city inspection within the first 3 years we lived there. And the lady had come up with a list of things that needed to be fixed, including the gas hookup for the dryer for downstairs. The faucets were corroded under the sinks. There was just a list of things they needed to come and fix. And they never came out and fixed them. She came again 3 years later because we've been there for a while. And she wrote it off as fine.
Okay.
You said she wrote it off as fine, you said?
Yes, like there was not an issue, but they never came and fixed the issues from the first.
Did you guys ever have to deal with any mold, any cleanliness, anything that you guys told them? Could you explain that to me? Also,
Yeah.
could you say yes, because
Yes,
the reporter can't hear
I
you.
currently have mold in my basement
Mhm.
and under the sink in my bathroom. I can't keep anything down there.
When you say you can't keep anything down there, could you tell me why?
It just
How
gets moldy.
it gets moldy?
I
The
just
mold.
usually just spray like mold
Okay.
stuff down there and keep
Okay.
it shut.
Did you ever let your landlord know about that issue?
The city inspector had said something about it. That and the fan in my bathroom doesn't.
You heard Mr. Dowrick, he claims that you guys haven't made any payments and that you just went radio silence on him. Is there a reason? Could you help me, I guess, better understand why you may have stopped communication with that person?
Well, after the last judgment, it wasn't, but maybe a couple days later where he started messaging about October. And we've had our electricity shut off a few times because our bill is through the roof, running space heaters, trying to keep the house warm. In the areas that we are, we obviously can't keep the whole house out with space heaters.
Okay.
So it's just been paying it. We have money for rent, but then you have to go pay water and light, a deposit and all that to get it turned back on because it got shut off. It just makes the bills a lot higher than what they should be.
Is this the first time the furnace has gone out, or how long has it been out? Just again.
The minimum 3 years.
A minimum 3 years?
It was not working properly before that, and his son did come out
Mhm.
and said we needed to change the filter.
Okay.
And we changed the filter quite a few times. We even bought extra filters, and it would kick on. He says it works, he leaves, it kicks on.
So for 3 years, you guys have had to go without?
No heat at all, yeah.
Okay, minus the space heaters and skyrocketed electric bills, due to such, okay. Okay. No further questions for this witness, Your Honor.
Do you have any questions?
Yes, Ms. Klish. You say the rent is currently 1,200. Could I show you this letter where the rent was increased to 1,300?
Well, you have to ask her a question.
Okay,
Maybe ask her, does she remember the rent being
Okay.
increased to 1,300?
do you remember a letter I sent to you on September 25th of 24, stating that effective November 1st of 24, your rent is increased to $1,300 per month? Are you familiar with this letter?
Well, without showing her, see if she remembers. If she don't, then without showing her.
I don't.
No.
Without showing her.
And
Okay,
if she doesn't remember, then I'll allow you to refresh her
Okay.
recollection.
thank you.
I don't remember the letter.
I'd like to show it to you. That's okay.
Does that refresh your recollection?
No,
Okay.
So you're saying you didn't see this letter? I have my copy of it.
I can't say that I received the letter.
All right. I mentioned text. I have a copy of the last year between you and me. There is no request for any maintenance
Is there a question?
whatsoever. Why, if you had an issue with a furnace or something else, why would a whole year of text go by without you asking for a repair to be done?
Because you told me I had to contact Brad for that, your son.
You mean, so you're going without heat, I want to understand this, you're going without heat for 3 years. This is a licensed rental property with a valid certificate with the city of Lansing, and you're not demanding that the heat be fixed?
I have demanded that the heat be fixed, but you told me that I have to contact Brad as the maintenance, that you don't deal with that kind of stuff. And like I said, the city of Lansing inspection, it can't even be, I don't even feel it's credible, because it was the same lady that came 3 years before that year. And she wrote up a list of things that needed to be fixed, and you or your son never came. And then 3 years later came and passed everything. So if the same lady said that these things were damaged, and then 3 years later, nothing was fixed, and she said they're fine, I don't find that credible at all.
I have in front of me the certificate of compliance for rental dwelling. And the property, it shows that the property was inspected on July 14th of 22. It gets inspected again next month. Do you recall this inspection?
I do. I was there both times she came, both years.
Do you recall the list of things that we were asked to do by the inspector?
I followed her for a little bit. She said the gas hookup downstairs was faulty for the washer and dryer connection. And she said that the fan in the bathroom needed to be fixed because it wasn't working properly. There was some smoke detector issues that was fixed that day. And there was corroding on the faucets and underneath the sinks. Those are just the ones I remember.
So the list, I have the list here. It's signed that everything was completed. So you're saying that these items were not done.
I'm absolutely saying neither you or your son came and fixed anything after the first inspection.
So we lied when we signed the form and said it was, everything was done.
Obviously, if that's what you're saying, then that's what you did, but I know 100% that neither you or your son came and repaired anything. And that was what was confusing, because the same exact lady came 3 years later and passed it 3 years later, and nothing had been fixed. That's when I started to wonder, what's going on? You guys have a personal relationship, or because how can it be faulty and nothing's fixed, and then 3 years later it's fine?
Did you call the city of Lansing and say, hey, I got problems with this house? They would come out and inspect it. Yeah.
I did not.
Sorry, Your Honor, I'm hard pressed to find why it's her responsibility.
But it's not an objection.
Sorry,
Well, it's gotta be an evidentiary objection. It's
I
irrelevant.
know.
It goes to our credibility, if that was your objection.
I have the text messages between you and Brad Dowrick. Brad Dowrick heads up the maintenance. All maintenance requests have to be in writing. The last time you communicated with Brad Dowrick was 2 years ago, February of 23. If you're having maintenance issues, why are you waiting 2 years without asking for one thing to be fixed?
He said it was a filter issue. He did come, he said we needed to buy new filters. I, at one point, had a conversation with you about maybe the ducts, because there's a lot of dust in my house, like when you turn on try to turn on the heat, the fan, anything. And I've even used my vacuum cleaner to try to get down in the ducts and suck some of that out. And I had that conversation with you years ago, and you said you were not gonna pay somebody to come and clean out the ducts. And I said, maybe that's why the furnace is cutting off, because I don't know. I mean, I'm not a repair. I don't repair furnaces. I really don't know what's wrong with it, but I do know that it does not work.
I have a question. I need some clarity. You're saying you've been without heat for how many years straight?
At least 3.
When's the last time you text? I didn't ask the question yet. When's the last time you contacted Mr. Dowrick or his son Brad Dowrick for maintenance on your furnace?
The last time I texted him.
Communicated with him.
The last, I can't say an exact date. It wasn't within the last year, because I've had conversations with Todd, like after court, or when he's been trying to get money judgments, and I've explained, like, we don't even have, heat doesn't work, we're paying high bills for electric, but I never knew until just now that a maintenance request had to be written. He just always told me to call his son.
Okay, but you're saying you haven't communicated with either of them within the last year about the furnace?
Correct.
Okay,
Why
are we here then?
I'm sorry,
Well, then why are we here?
I don't know.
If your client hasn't communicated about an issue, how is he supposed to be? And there was a judgment. When was that for a non-payment of rent, or?
It was for non-payment rent on August 21st. That was paid off,
For what, August of last year?
August of 24.
So there was a court case last year and this wasn't an issue then?
No, it was not.
Okay, so there was a judgment, and then nothing brought up then about condition of the property. Now we're here, rent still not being paid, and then no record of communicating even since that judgment or in the year of that judgment of an issue with the property. Why are we
I believe that
here?
She didn't communicate with them because her communications thus far have fallen on.
That's not what she just said under oath. Under oath, I asked her, when's the last time? She said, not within the last year.
I mean, prior to this last year, Your Honor, I do apologize. My understanding is that from at least 3 years ago, she's been trying to get this furnace fixed. I would too stop asking to get it fixed if a year
I
goes
wouldn't
by.
live with a house with no heat
I agree.
and expect to be there and pay a high bill. I would move. I would call the city.
Mhm.
I would do a number of things. I can't put myself in her position. I can only ask, I can only follow what the law dictates. And that is, if you're gonna be in a property as a condition, and you want to use that as a reason why you didn't pay your rent, there's certain things you have to do to show good faith. Number one, you gotta put your rent in escrow. It was their rent escrow.
No, it was not.
And number two, you gotta notify the person that there was an issue. It can't be, well, I told them 3 years ago that there was an issue. She said that he came out there and changed the filter. Well, what do you tell him since then? I need some record of some communication. And if I got record, I haven't reviewed his text messages yet. If I review these text messages and I see where he's communicating with her regularly, asking for his rent, and there's never a response that says, sir, you have not fixed our heat, then it doesn't sound like good faith here.
I believe that at least for August, the rent wouldn't have been, or the heat wouldn't have been an issue because it's August. I don't know when or if they've ever had any other.
He said he's got a year worth of text messages there. Is that
Yes,
correct?
ma'am. A year worth of text messages.
I have a year worth of
Just-
text messages, no request for any repairs whatsoever.
You reviewed those text messages?
I have not seen those text messages.
Well, before I gotta see him, he's gotta see him. We'll go off the record so you all can review that, because I'm not 100% sure why we're here right now. It sounds like something that needs to be resolved. Because if I make a ruling, someone's gonna be upset.
Would you like us
You can take off this, you can step off the stand for now. We're off the record, because I can't review those messages if your attorney has not reviewed them. And then we'll, once you review them, we'll see if he wants to admit them as an actual exhibit, which he's not formally asked, but it looks like that's what he's trying to do.
Yes, ma'am. Would you like us to take-
Yep, you can step off and then I'll call the next case. I'll call you when you're ready.
Take it on.
Thank you.
The guy that was in red. He was downstairs.
Oh,
This wasn't on the jail. So I wasn't sure.
well, that's not good.
Yeah. The jail clause, that's how.
He is here.
Yeah, he's downstairs.
Well, you can come watch the video then.
Yeah.
We can do the pre-trial if he's here.
Oh, okay.
Yeah, if he, we'll have him brought up. I'll box the pre-trial, and then I have luckily have two people from legal services here if he wants to do an intake, but
Oh, okay.
yeah, so,
Then I'll just wait on the commitment.
yeah, that way we don't have to.
I
we
thought
can-
maybe you heard the case this morning. I wasn't sure.
No, we didn't know we didn't know that he wasn't here because he wasn't on the jail list. We thought he wasn't here. And so we'll just now convert it to the next one to a hearing,
Okay.
and we'll have him brought up. Thank you.
No, thanks, Judge.
You still need me to sign this?
I mean, I do need you to sign it. Don't need it to take him back. Okay, well, actually, I gotta go.
Alright.
Thanks. Thank you, Judge.
Ready to do that one. Okay, Oak Sparrow Properties and Sandy Property Management versus Chase Carson and Amanda Williams. What's your name?
Chase Carson, yeah.
What's your name?
Amanda Williams.
Oh, that's it for me. Household appearance.
Good afternoon, Your Honor. Jessica Larson on behalf of Plaintiff Oak Sparrow, along with representative of the property.
Okay, today was the date set for hearing. This is for termination of tenancy. Did the parties come to a resolution?
We haven't spoken on this one, Your Honor. From the prior hearing, my understanding is we've got quite a dispute. I don't think that we're in dispute on possession. The tenants are indicating that they actually vacated far before we believe that they did. So I don't know. I don't think that a resolution is likely on this one, Your Honor. I do say that I will say the issue of possession is probably moot because the tenants are indicating moved out.
I don't know what prior hearing you're talking about. I have a note here. Let's see. It's a pre-trial. Present, then it's no longer in possession of property. There was a hearing for the 18th. Okay, so what happened? you're saying you vacated the property?
Yes, Your Honor, I was served a 7-day on May 24th. I'm new to this whole process. I've always paid all my bills, so at that point, I uprooted everything that I could take, including my family, and we vacated the property. I attempted to make a phone call to Miss Sandy Bristol, fell upon deaf ears, as many communications had to that point. I, at that point, thought this was all behind us, and then
A
all of a
communication
sudden.
saying that you had vacated, is that what you mean?
Yes, I attempted
Okay.
to contact her and let her know the key was on the counter and we were out of there. No response.
Do you have record of where you?
I did text her and ask her why on the day of the that I received the 7-day. Because at that point, it was to my knowledge, we were doing everything that we could to stay in the property because we had previously had a case due over our animal that they tried to evict us and they lost in court. But for whatever reason, that still shows up on our record. So when we attempted to go get a new home, when they refused to renew our lease, we have a red flag. I can't rent anything. They won't even show me places. So I reached out to Miss Bristol and in good faith, I said, I will do whatever it is in my power to keep my family in this home. I jumped through their hoops. I gave them record of my dogs. I obtained insurance. They
Are we talking
walked
about
the
this
property.
eviction though?
What's that?
I'm talking about this eviction, not the previous one.
Yes,
Okay,
yes. So, I'm sorry, I guess I misunderstood.
okay, because I thought you were talking about there was another eviction.
There
About
was
an
an
animal.
attempt at it.
Okay.
They were ruled against in the
Okay.
courtroom.
So since receiving
that
this notice
eviction
of
has put-
eviction, that's when you reached
Yeah,
out and
that-
said you would do anything?
Yes, after
Okay.
when I attempted to, because then we went back and finished out our lease, and then we got a letter in the mail that they are choosing not to renew. So I was like, that makes sense. And I attempted to find a place. When I realized we were blacklisted and I couldn't even rent a place, then I reached out to them and said, I'm willing to do anything that you would like. And I did everything they like. They walked the property. Everything looked good. There was no damage to the property. And then all of a sudden, the letter comes in the mail, you need to leave within 7 days. So in fear of another thing going on my record, I took what we could and we vacated there. We were gone before June.
When you say you took what you could, doesn't sound like you took all your stuff.
No, ma'am. No, ma'am.
Well, then you didn't turn over possession.
Like I said,
What did you leave there?
I had just things that we didn't have space to store or anything. I took the possessions, our day-to-day possessions, and we bounced around since. We were going to make an attempt to clean the place up if that was their request, but again, she did not give me any communication back and forth until we got a new court date.
So you
After
communicated with her in via text after you left?
Yes, I asked
what
her
did you
on the
say?
24th, I said, why? And she says, you have continued to ignore us. You never submitted the animal application and the dogs were an issue. It's too much of a liability.
Did you
Well,
tell her
I
that you
do have-
vacated? Did you tell her that you vacated?
No, because I hadn't at that point. This was the day
Okay,
that I
wanna know
received the
what,
7-day.
I wanna know about you communicating that you vacated.
That was a telephone call.
Okay, you called her?
I don't have a record of the telephone
Did
call.
you
that's
talk to her on
logged
the
up.
phone or did she not answer?
No answer.
Did you leave a voicemail?
I was not able to leave a voicemail.
Why not?
To be honest, I don't know if her mailbox was full or what have you, but I wasn't able to leave her a message at that time.
Okay, so how was she supposed to know that you vacated?
Answer the call.
Okay, so when you called, let's say she was tied up and busy, couldn't answer. Or maybe technology didn't work well, and she didn't even know you called.
I don't know how to answer that for you. It was a confusing, scary time for me. I have not experienced things like this. I just like I put my hands in there. We're out of here. Like I've done everything I
And
can.
you
do to
left the
stay
keys
here.
there, you said
Yes.
at the property? Okay, counsel,
I'm sorry, Your Honor.
counsel, did the property appears to have been vacated, but there was a number of things left there?
There was a substantial amount of things there left, Your Honor. From my understanding, the tenants continued to reside there because they were paying utilities there. And so the date of the hearing that I think Your Honor read, that was in front of Judge Buchanan. My client didn't get notice of the utility switch over. There was no indication of keys being left. There was no written notification. There was no verbal notification. Up until that hearing, we had no idea that they were going to even claim that they had moved out back in May.
Where were you still paying?
Well, we had
Utilities?
past due amounts, so I was paying the minimums at that time to keep my name from getting to the point where I wouldn't be able to put utilities in my room at the next, or I mean, my name at the next residence that we would be at.
My client didn't get notification of any utility turnover until, again, after the hearing that was before Judge Buchanan back in November.
which all would have been communicated had her client answered the phone call, but she put me
Well,
on
you didn't-
silent. do
You
not
didn't change the
disturb.
utilities over to your new place. Where did you, when you
I
left? where you
can't
moved?
find a new place because. of
Okay, so
this
you don't have a new
situation. No,
place?
I'm bouncing around, staying with my mother at the moment.
Okay.
This has created quite a
But,
situation.
but
for us.
you didn't disconnect the utilities at the place, you just was paying the bill, you have some evidence of the utility bill?
No, I don't have evidence of the utility bill.
Do you have any evidence of what was left in the property?
I have a ton of videos and photographs, Your Honor. My client has also gone by the property several times and can indicate that the vehicle that Mr. Carson and Ms. Williams, that vehicle was outside of that property on many occasions when she was driven by. There's a ton of
Yeah.
stuff outside of the property. There was absolutely no indication that these parties have vacated. There's shoes on the porch.
Show your
there's-
evidence.
And Your Honor, I will say too that the client,
Was there any physical evidence of us being there or a picture of my vehicle there? Because I can guarantee that wasn't the case. They
And I can-
they park
Okay.
in the driveway next door.
Okay.
well, how would you know where my client parked?
Where are you, if you all wanna talk,
They
off the
didn't park
record,
our
off the record, bye, you can talk outside. If you wanna talk to each other, if you want me to handle it, then you talk to me, you can talk outside, next case. On the record, in the matter of the people, I'm sorry, a matter of 421 Seymour LLC versus George Odell and 24-08615.
Thank you, good afternoon, Sam Joe, here on behalf of plaintiff.
Sir, what's your name?
Josh,
Okay, today was the date set for hearing for non-payment of rent. Did you all come to resolution?
Yes, Your Honor, I have in front of me a consent landlord tenant judgment signed by both parties. Would you like me to go over the terms or
Yes,
just approach? Okay, thank you. Rent to retain possession, $3,650, cost $246.10. Total $3,896.10 to be paid on or before February 28th, 2025. Partial payment will not prevent a default in this matter, and a money judgment was paid for and paid for. Prorated rent, $2,678.57, cost $246.10, total $2,934.67, should the other amount not be paid by February 28th.
If that's complete and accurate as to your understanding of how you want to proceed, sir? Thank you.
Thank you.
Okay, so you understand, sir, that you do have the right to have a attorney represent you in this matter?
I do.
Do you want to give up that right today?
Yes.
You also have the right in this matter to proceed to trial. You could have demanded a jury trial, or we can proceed with your hearing today, if that's what you want. Do you want to give up your hearing?
Yeah.
Okay, anyone threatening you to give these rights up? Who's threatening you?
Oh, no, nobody, I'm sorry.
Oh, okay. Okay, so you're having judgment entered by consent whereby you agree to vacate the property at 421 Seymour number 2, or pay the past due amount $3,650 plus court costs of $246.10 for a grand total of $3,896.10. You'll pay that in full or vacate the property by the 28th of February. Money judgment will also enter into a total amount due $2,934.67. You have an appeal date. It looks like the date here is for the 24th of February. Yes, okay. You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you've given up, you can return to the court, request to have this judgment set aside, and then we will set it for a hearing for you to explain how it was that you misunderstood your rights, okay? Do you have any questions for the court? Okay, any additional matters for the record?
Yes, Your Honor, thank you.
I'll get you a copy in just a moment.
Thank you very much.
Thank you.
427 Seymour, 104. Hi, you guys.
Which matter are you here for?
This is the Shiawassee Apartments versus Joe Brown. We did submit.
I signed it.
Okay.
I printed a notice.
It's your note, yeah.
Okay.
I signed that this morning, that day.
No abundance of caution.
No worries. There a notice for that? Oh. Oh, he was walking.
Your Honor, I can return to the courtroom. There's-
Okay,
And
Sir?
For this matter.
Okay, sounds good. Let me play the video for him. Sir, I'm gonna have you sit here because I have to play a video for you. This is an eviction proceeding that you were brought over for. And so this video is gonna tell you about your rights, okay? It also go over resources that you may be able to access to help you avoid an eviction and potential ways to resolve this eviction. And then when you're done with the video, someone from legal services can meet with you if you'd like. And they can do an intake to see if they can represent you, okay?
Okay.
And then when you're done with
Welcome to the 54A District Court. Please listen carefully for information about your rights and resources that may be available to assist you. Please have paper and a pen handy. You have a right to retain an attorney to represent you. If you do not have an attorney and you can afford an attorney, you might locate an attorney by calling the State Bar of Michigan at 1-800-968-0738. If you are a tenant and you cannot afford to hire an attorney, you may seek free representation from legal services. You should have received this information with your summons and complaint. There may be a representative from legal services available today to speak with you. You have a right to proper venue. If your residence is not located in the city of Lansing, you have a right to ask the court to transfer the case to the district where the property is located. You have a right to a jury trial. If you want a jury trial, you must request it orally in court today, or you may file a demand within 5 days. You are also responsible for paying the jury trial fee unless you have requested a waiver. Assistance may be available from the Michigan Department of Health and Human Services, the local coordinated entry agency, or Abbott House. Those agencies may be able to assist you with payment of some or all of the rent. You do not need a judgment for assistance. The summons and complaint are sufficient for your request for assistance. If you have served in our armed forces, assistance may also be available for the Michigan Veterans Trust Fund. Please call 1-800-642-4838, option 6. If your case is a non-payment case and you have already applied for assistance from one of the agencies, please be sure to tell the judge. You will be required to submit written proof to the court within 5 days. The 54A District Court has an eviction diversion facilitator on site to provide non-legal assistance, such as connecting you to possible resources. Please contact Ulysses Rosa at 517-483-7608. Your landlord-tenant case can be resolved in a number of ways. One way to resolve this case is if you and your landlord reach an agreement. In such case, a conditional dismissal is possible when approved by all parties. The court can provide you with a form for a conditional dismissal. Another resource is the Michigan Community Dispute Resolution Program. If the court determines that your case can be resolved through community dispute resolution, then that resource will be coordinated by the judge. Information about your other rights and the legal process is also available from the Guide to Michigan Legal Help at www.michiganlegalhelp.org. Thank you for your attention. Your case will be called shortly by the judge.
It's gonna be March 5th, okay?
Okay,
And if you're in county, we'll have you written over, okay?
I'm sorry.
If you're still in the custody of the in-county, we will have you written over for that purpose, okay?
Okay,
Did you want to meet with legal services today to do an intake?
that'd be nice.
Okay, we'll get you over in a private meeting room, okay?
Okay.
Thank you. Mr. Kuntz, are you here for a matter? What is this?
He sent the email right here, but I just sent the papers.
Kristen's not in custody?
No.
Okay.
Yeah, I got that. I'm gonna go check and then one more part. And then I'll put that. Okay.
Your Honor, we were unable to reach any kind of resolution. I don't know if you'd be ready to call the case.
Not at this, I'm taking care of something else right now.
Thank you.
Mr. Kuntz, have you spoken to the AG on this?
Yes, I have, Your Honor. We
That's
have
fine,
a
stipulation.
Stipulation order. I just want to make sure it's okay with it.
Absolutely. I don't have to, the timeline's been waived, so
Okay,
Thanks.
we'll get that over the court.
Thank you.
Thank you. Stay safe.
safe too. Let's see, Mr. Bach, what's the matter?
Got the non-Liddy Silly Goose versus Fields and Riley.
Okay, are you ready on either?
I am. I called the hall. There's no response.
Okay, you can submit the default. You have the default paperwork with you?
Excuse me?
You have your default paperwork with you?
I do. I'm gonna have to write on it that the money judgment only applies to Mr. Fields.
Okay, you have, okay, just one matter, correct? The Woody matter?
Yes, I think I'm back here at 3:30.
Okay, sounds good. Anyone here for Huntertown Properties versus Camille Gonzalez?
Yes, we're ready on that.
You're ready on that?
Yeah.
File number 24-08605. Here's for the record. You Camille Gonzalez? You come on. Appearance, please.
Yes.
Gonzalez. Okay, counsel, you can put the agreement on the record.
We had a chance to speak, Judge, and it's been brought to my attention that there are some maintenance issues that we'd like time to address. So we actually would like to put this over 30 days if possible. And we'd also like to submit an escrow order for rent to be put into moving forward. I don't have that order prepared, but I
No worries, you can file it on my file. March 12th at 1:30.
very good. Thank you, Judge.
We'll probably get your notice to appear, okay? You're all set for today. Let's see. Ma'am, you were raising your hand. What's your name?
Bring a breath.
Okay, you're here for 245. Same attorney is on that, though, or should I make that up? You're a different Levine. Counsel?
Elijah
Oh, yeah.
You're on that, right, counsel?
Yeah, we actually submitted a consent order for conditional dismissal.
Still has to go on the record.
Yeah.
When your attorney's ready, we'll put it on the record.
Oh, yes.
He's not, I don't think he's here yet. I think he's handling another matter, but if he can take a break, we can get it taken care of.
Okay, sorry about that.
Okay, back on the record, counsel. And this is Oak Sparrow versus Carson and Williams.
Thank you, Your Honor.
And you've not come to resolution, correct?
We have not. It sounds like we're at an impasse, Your Honor.
Okay, so then you need to talk to me and not to each other. Back and forth is not gonna be allowed. If you start back and forth, I gotta move on. Look, all these people behind you waiting for their turn.
Apologies, Your Honor.
Okay, I'll allow you to present your evidence.
At this point, Your Honor, it sounds like based on some of the claims that the tenants are gonna make as far as the utilities and how those were paid, I'm not able to access that. My client is not able to access a record that is in the tenant's name without a subpoena. So I'd ask the court to allow me to issue a couple of discovery subpoenas and reset this matter.
You said about how the utilities were paid, you mean?
Yes, my understanding is that utilities remained in the tenant's name, that they were paying those regularly until that November hearing with Judge Buchanan. The tenants are now claiming that they were only making the minimum payments and they were paying past due amount. I'm unable to access those records. My clients have called and they've tried to get them, but the utility companies obviously are not going to release an account in someone else's name. So I think that would be an essential piece of evidence in this case. And so I'm asking for the ability to issue subpoenas to Water, Light and Consumers.
That's fine. Is the property secured and winterized?
My clients have gone into the property, Your Honor. I don't know if they have, I would like an order actually confirming the possession that they can retake it, because they have gotten a notice from the city that they've asked for an extension until Monday in order to remove trash that's from the property, otherwise they're going to give the violation.
So there's trash that you're saying that they left, can I see?
Yes.
Your Honor, that's something that I'm privy to as well.
Okay, so it's front porch. This is from the code enforcement. They said that there was trash found in boxes, bags, and barrels on front porch, clothing and cloth products on front porch, deteriorated metal product on front porch, loose trash and debris, front porch, in yard, around and behind the house. Did you leave trash at the property?
I guess you could consider it trash. Yes, there were several items that I explained that I had no choice but to leave behind. I didn't have.
No, you have a choice.
I did not.
You do have a
I had the
choice.
financial ability to do that.
Did you put the trash there?
I'm sorry?
Did you put the trash there?
There were items in the home.
Did you
and
put the
interpreting
items?
them as
Did
trash
you
is
put
not
the
trash.
items? Did you put the items that have accumulated causing code compliance to come and issue this concern violation about? Did you put it there?
On the porch, no.
So the things that are not yours, how did they get there?
I don't know. They've had the property.
Do you have
since May.
pictures?
I have some pictures of the exterior of the property, yes, Your Honor.
I can't say what they're.
I didn't ask you to speak right now. Do you have copies for him?
I handed him one.
Okay, I see a helmet, I see a, look like child's car, a welcome mat, or something, welcome thing. I don't know what this is.
Again,
I didn't ask you to speak over me.
Oh, I'm sorry.
It looks like something else on the porch. I don't know what it is.
It's to be boxes and shoes.
You said boxes and what?
It looks to be 2 empty boxes and a pair of shoes.
What are the toys in the front yard?
Those were toys that my children played with outside that I have nowhere to store now. So they were items that were, yes, and left behind.
Okay, so there's shoes, there's boxes. I do see debris. You didn't put those there?
I'm sorry?
You're saying you didn't put these things there?
That's why I said, is it trash or what are the items so that I can specifically tell you? Like, I wouldn't consider my kids' toys trash, but to each their own opinion.
You left the things here?
Yes, Your Honor.
Then you think that they're supposed to be responsible?
This
for
photo
giving-
was taken while we still live there, by the way. That item is in our, that football helmet is currently in our possession. I don't know where these pictures were taken or when, but that time frame they just gave you is wrong. Actually, multiple items that are in these pictures are currently in my possession.
Could I ask him to confirm what date he's going to say that he moved out?
What date did you move out of the property?
It would have been May 30th and 31st.
My
That
client
was the
took these
moving.
photographs at the end of June.
Any other evidence that you have today?
I have a witness with me, Your Honor.
You can take the stand.
Okay.
Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can have a seat.
Ma'am, can you state your first and last name and spell your last name for the record?
Jennifer Willcutt, WILLCUTT.
And are you a representative of Oak Sparrow Properties?
I am.
Are you employed by Sandy's Property Management?
I was in 2024, yes.
Thank you. And are you familiar with the file for Chase Carson and Amanda
I
Williams?
am,
Have you, and they've lived at 1317 West Shiawassee Street.
correct.
Have you, since May of 2024, have you been to that property?
Yes,
More than once?
I drove by the property at least once a month from June until November 20th was the last time, because I was told that they had told the court they had vacated.
And that's all through 2024?
Yes,
And did you observe any changes in the property between May and November?
yes,
Did items appear to be moved?
yes,
Did it appear to you that there was somebody residing in the home?
yes.
Are you familiar with the vehicle driven by either Chase Carson or Amanda Williams?
I've seen Chase put dog into I think it was a white kind of work type van possibly, or a panel. It was a type of, yes.
So you would recognize their vehicle?
I recognized it on the street, yes. I wouldn't recognize it out in traffic.
Fair enough. When on these occasions that you've described driving by the property, did you observe that vehicle?
Once or twice in the street, yes.
And that was a vehicle that you had seen Mr. Carson access?
Yeah.
At any point in time over the summer of 2024, did you get any notification from the city regarding any unkept lawns?
No.
Was that an indication to you that the lawn had been kept appropriate for the
Yes.
city? I'm sorry? You said something, sir?
Do I need to?
I thought he was interjecting. I'm sorry, Your Honor. Okay. Are you familiar, have you been in contact with the utility company in regards to 1317?
Yes,
And at any point in time, have you received notification that the utilities are being transferred into Oak Sparrow's name?
no.
What is your understanding of the status of the utilities?
On November 20th, 2024, there was no water or electrical service. I called Lansing Board of Water and Light at that time, and they told me that services were turned off on November 18th, 2024. I called Consumers Energy on November 20th, 2024, and they told me that gas service was still in Tenant's name as of November 20th, 2024. I later went back to make sure that the property was still secure on December 5th, 2024, at which point there was no gas service. I called Consumers and they said that it had finally been turned off in Tenant's name on December 3rd, 2022.
And you said you appeared at the property on November 20th initially, and then
Yes.
again on December 3rd. Thank you. How did you gain access to the property on November 20th?
I was told that they had stated that the tenants had stated in court that they had vacated the property, and I was asked by my superior at the time to secure the property. So I asked maintenance to please schedule a time to go over and get the locks open so that we could change locks and secure the property properly. No items were touched or anything.
When you appeared on December 5th, did you notice any differences in the property?
The door was open and it looked like to be some kind of snacks or something on the stairwell and the living room. Things had been moved around a little bit, and that was about it.
Can you just?
Oh, the garage door was also, we had secured the garage door and that had been opened up as well, and it was like items that been moved around in the garage.
The photographs that have been presented to the court for the outside of the property, is that fairly representative of how the interior of the property was kept as well?
The interior has a lot more trash and items left out than the exterior. The exterior is not the worst.
Can you give a general description of the interior of the property?
There's a large mirror in the middle of the kitchen. There's trash bags that the mice have now taken over. There were baby and children's toys in the living room. I think some type of small animal bedding, a bag of animal bedding was in the living room. And then there's just general personal property throughout, clothing items, shoes, children's.
Were you able to speak with any of the neighbors who live nearby at 1317?
Yes.
And did they give an indication of observing the Mr. Carson and Ms. Williams there?
It's hearsay.
At any point in time, have either Mr. Carson or Ms. Williams indicated to you or to your knowledge, have they said that they were moving out?
No.
In April, did they indicate that they wanted to renew their lease?
Yeah.
Were you working on actively renewing the lease?
We were actively working on a month-to-month agreement.
What's your objection?
That is not the truth.
Objections are for evidentiary foundation, not that you dispute what she's saying. So if you dispute what she's saying, when she's finished, I'll give you an opportunity to give your testimony, but that's not an objection. So you can continue, ma'am.
Thank you. Did Mr. I want to call him the Carsons, did Mr. Carson or Ms. Williams turn in their keys at any point?
No, not to my knowledge.
Did you ever receive any written notification that they were terminating their lease?
No.
Did you actually appear at the property on May 1st of 2024?
I did.
What was the purpose of that appearance?
To inspect the home to see if there was any animal damage and to give animal applications and to explain what paperwork the owners have requested in order for them to stay in the property with their.
And so that was part of a process of extending the lease.
Correct. Mr. Carson also provided me with documentation for the dog licenses and vet records, which I did copy for him and return on May 7th. I did not enter the property on May 7th.
After May 2nd, did Mr. Carson ever indicate to you anything different other than moving forward with renewal of the lease?
No.
Are there any other facts or details that you think would be relevant to the court as far as this matter and whether the Carsons moved out in May?
The picture with the football helmet that was brought up, I took that personally, and that was on June 27th. The trash bin was also at the curb. On November 20th, the trash bin was in the backyard by the garage.
Any other details that you recall of items being moved around or?
There's a small child's car, I believe it's green. When the picture on the front, I think, shows it in front of the stairs, that on November 20th, that was moved into the fence area. It was.
And the helmet's missing.
And the helmet wasn't missing.
And then had the tenants paid any rent between May and November of 2024?
I believe their last payment was May 2024, mid-May.
Do you recall offhand the unpaid balance that's owed to the tenants?
I do.
If I showed you a copy of the ledger, would that refresh your recollection?
Yes, it did.
Go ahead and take a look at that. Don't testify from it, but when you read it, okay. Do you recall the amount that's unpaid rent for the tenants?
$9,900.
Thank you. I don't think I have anything further.
Do you have any questions for this witness?
One second.
So you say that you've gone by once a month at least to check on the property.
Yeah.
And you've seen a vehicle that you believe to be mine there, correct?
A few times, yes.
And what was that vehicle?
I think it's a white van or some type of panel that has doors on the back.
Your Honor, I have no white van. I
Check.
do not own a white van.
Okay,
I've never.
This is
owned
time
a
for you to give or ask her questions, not time for our.
Oh, okay, sorry. Yeah, that. And are you familiar, you said you were familiar with neighbors then?
I did not say I'm familiar with the neighbors.
Okay, are you aware that they have children there?
I did not.
Okay, and are you aware that children will play with toys if they see them, such as a power wheel left outside that could move a couple times?
Objection
Because
calls for
kids-
speculation.
Just saying that the neighbors next door, they have several.
The question
children
is
that
it
play with
possible,
toys.
is it possible that the neighbors?
Yes,
could
is
have-
it possible that someone
That-
else?
No, I'm asking you, was that your question?
Yes, Your Honor. I'm asking, is it possible that someone else may have moved a toy outside the home? That's what your ground you're going on.
Objections
for us to be
overruled, you
there?
can answer it.
I guess anything's possible.
Okay, and any of the times that you have drove by the home, did you physically see myself or any member of my family? Okay. And when you called to ask about the utilities, they wouldn't speak to you, correct, about how it works, so it's a good possibility that we were paying the minimums to keep our
Objection,
name from
argumentative.
getting.
Well, That
And
would cause
speculation.
speculation. That causes speculation. You don't have to answer that.
Okay, well, my point, Your Honor, is that in order to get something taken out of your name, you have to pay it in full. This came out of nowhere. I had no means to pay it in full. That explains why the utilities were continued to get paid and stayed in our name right up until the point where they just shut them off. It wasn't turned off because we.
I
didn't
understand
want
you,
them.
you've cleared that with me, with
Okay.
the, as part of why you made those payments. They're asking for a continuance so that they can get the records. I'm just getting their testimony now, so when we come back, we don't have to do that.
I understand.
Do you have questions? Any more questions?
Not for her, no.
Okay, thank you. Any redirect?
Why do you believe that Mr. Carson has ownership of a white van?
I have seen him putting 2 dogs in that van on May 1st. About 5 minutes before our agreed upon appointment, where Sandy, Davey, Bristol, and myself toured the property and spoke with both tenants.
So whether he owned it or not, he certainly had access to it.
He had keys that unlocked, and he opened the door and put 2 dogs in.
No further questions.
You said you had video, or is this what you're talking about?
The video, Your Honor, was taken by another witness who
Okay.
is out of the state at the moment. So if we do come back, I can present that, Your Honor, and have her testify.
Okay, sounds good. I'm going to give you this evidence back for now. You had an issue about the property. You wanted an order?
Thank you, Your Honor. I'd like an order for immediate possession and reserve the money judgment for a continued date.
Well, order for possession is granted. They said they've already turned over possession
That's never been.
of
a
the
question.
property. We'll deal with the money judgment. We'll continue for the money judgment issue.
Right.
Obviously, if they have to clean up trash and debris, that goes towards their money judgment claim. You do understand that, correct?
What's that?
If they have to go into the property to clear out the trash and debris, that costs money. And so that's also evidence that will go towards the money judgment. You
And
understand
now, I don't know if it's possible or anything, but I would have had no problem communicating that with her, that I would be willing to take care of those items and get the property up. to
that?
par,
No,
but
you
she
just
didn't
told
answer.
me earlier that you had no choice.
No, I didn't have the means that within 7 days, but then I can say
No,
I can
but
come back with a truck
It's
when I can afford
it's
it.
been 6 months
Yeah,
since you
it was
said you
a-
left.
Yeah, and I just assumed they wrote it all off. That's why we're here today.
You could know soon that they
And
filed
I
an eviction.
also. Go ahead.
They've been on notice of this for several months, Your Honor.
You couldn't have assumed there's been an eviction pending, so you knew that the
And
eviction was still
is it
pending.
general practice for them to drill out the locks and give themselves back the property without a judgment from the court?
It's not general
Okay,
course,
'cause that has
however,
happened.
it's also not general course to leave a property. That's why I asked, was the property secured? And was it winterized? Because if you vacated a property, if I take what you say to be truthful, that you vacated a property in May and that you called one time, no one answered, you left no voicemail, you never followed, do not talk while I'm talking. You left no voicemail, you never followed up, you never got any word to make sure they knew that the property was vacant. That means you left the property exposed and any animal, creature, person could come and take over this unit because you just left it abandoned with things there. When you leave things there, they don't know off the top that you have moved or rendered possession unless you notify them. And this is if I'm taking what you say to be true. And then on top of that, there's still electricity going to this. So if they check the electricity, they see that's still going on. So there's no reason for them to believe that you vacated unless you have communicated to them that you have vacated. It is now the dead of winter. We're in the middle of a snowstorm. It's going to be 0 degrees. That's why I asked, was the property winterized? Because if it wasn't winterized and those pipes freeze and burst and there's damage to the property, and I make a ruling that you have not properly turned over the possession, then now you're responsible for the damage if pipes freeze too. Do you understand how that works? Okay, so what is it that you feel like so urgent that you need to share with me?
I was just wondering, am I the only one that's responsible for communication? They had any questions they couldn't have reached out at any point during this? Do they have any attempts to reach out to me or any of my people
No,
to resolve it?
they did reach out to
Other
you.
than court?
They filed a notice to quit and vacate, and then they filed a summons and complaint to bring you to court. They have communicated.
So-
If you have vacated the property, your responsibility is to let them know that you have vacated and turn over the key.
Should they choose not to accept my calls?
You didn't, you testified 1 call. That was your testimony.
Yes, I'm aware.
Already have enough for possession. You didn't turn over.
I'm not questioning.
Yeah, you
possession.
didn't
I'm
turn
just saying they
over,
took it
you
without
did
me
not
saying
turn
so.
over possession reasonably. It's not,
I just was
that's
under the
not
impression they
reasonable.
took it unlawfully.
Well, you left,
There was never a judgment for them to go in and drill out the locks.
you
and
mean,
give them
oh,
access.
when did they do that?
I have no idea.
So how do you know they did that?
Because I went there after our last court date, when I was realized that they thought we were still there.
After the last court date when you told me you had vacated in May?
Yes, I vacated in May.
So you're saying in May, they drilled out the property and
I
changed the
have
locks?
no, man, I have no idea what their time frame for lock drilling was. I
No.
know in November, when
You
I
went in
went there,
November.
the locks were drilled out.
After you've already communicated
When
that
I
you had,
found out that they thought
after
we
you
weren't
had
there.
already communicated that you didn't live there?
Yes. Because
So then
at
what's the
that
issue?
point, they thought the property was still mine.
No,
As
at that
far as
point,
that's
it's the
concerned.
middle of the winter
They're
and you
still
claim you
charging
left.
me for it.
In the middle of the winter, you claim that you left and you left all your stuff
No, I
there.
didn't claim.
And you said
I
that
left
it's not
in
your
the winter. I told
responsibility
you
to get it
May,
out.
Not the winter.
Judgment for the plaintiff
For possession or money?
and money. Done.
Thank you, Your Honor. Can I include standard cost in that?
Absolutely.
Thank you, Your Honor.
Thank
I'll get
you.
that submitted on e-filing.
Can I
Thank you.
object? I mean, can I
You
like?
can object all you want. I'm done. Thank you.
We weren't even there. They're getting. This is.
Do you want me to have you escorted out?
Oh,
Excuse me? You want contempt next? Because I can give you 93 days in jail. Thank you. On the record, back on the record in the matter of Dwick versus Little John and Clish. Okay, counsel, you had opportunity to review the text messages. I'm assuming he's making a motion to have these admitted as exhibits.
Yes, I am.
Any objection?
No, your only objection, not objection, personal, I guess, point of contention. I don't think text messages are the only way to communicate. My clients have held the date.
Oh, I asked her under oath. She said she did not communicate with him about it for a year, so that's, I asked, oh, I didn't, I said communicate.
I'm aware.
I said, when was the last time that you communicated with him about the furnace? She said, not within the last year.
She was under the assumption that we were still talking about text.
She was not, because I clarified it on the record.
All right.
I said, she said text message, I said, no, communicate. Okay. Did you have any other witnesses? I need to see the text messages, please. Is there any photographic evidence of these conditions on the property, the alleging mold? Something to show me that the thermostat didn't change when the heat was turned on? Any evidence?
All that stuff got not transferred over, so. Do apologize.
But the person, you still live in the house, correct?
Yes,
You have a phone?
I do.
I don't see how that works. They could do that this morning.
I wasn't aware that it was gonna be like a full trial. Usually we go to court and then they set a day for trial or.
We do that already.
It got
You had a
slowed
pre-trial.
down.
No, that's.
Oh. Oh.
Okay. This is very simple. You have a non-payment of rent. You have a copy of, I think the issue that's not so simple is how much the rent was. I think we understand, at least at one point, it was $1,200. But you're claiming that there was a letter that was sent to them. How was it sent?
It was sent by US mail. I have my copy. It's a carbon, I have my carbon copy of the letter.
You sent when?
It was sent on September 25th, of 24, stating that effective November 1st of 24, your rent is increased to $1,300 per month. The ledger reflects $1,300 effective November 1st. Would the court like to see the ledger?
All right. So I have your text messages, and I'm looking at the pattern and how you started telling her every time. Well, you've been consistently telling them every time, or her at least, every time the rent was due and what she owed. And I see when it shifted to $1,300 increments. I don't see any response that, hey, that's not how much my rent is due. I don't see any response. Primarily, the reason why I have a concern about the credibility of your witness's testimony is because it's unreasonable for me to believe that for 3 years you live in a home where you're paying $900 to $1,200 a month and you have no heat, and there's not a single text message when I have a year's worth of very active communication, and you don't mention, I don't have any heat. At one point, she stated she didn't even have Brad's number. Well, if you're communicating with him about maintenance issues, you would have his number. So she wasn't communicating with Brad because she said in the text message she didn't have his number. Not only that, there was another eviction within the last year and a judgment where this was not an issue. Rent, it looks like from January of 2024, which is what the messages I have, there's constant and continuous text messages being sent to the tenants about the rent that is owed. There's not, responses are always, my mistake, you're right, I'm gonna give you the payment, I'm gonna give the payment to Brad, then I don't have Brad's number. I mean, there's communication about your rent's due, and there's a communication about the condition of her vehicle. She's got a nail in her tire, or her fiance or boyfriend, whoever it is that's living with her, is laid off, or her truck has a flat, or she's not working, and he wants to know if she's still working for Matt and Heather. Her goddaughter is in the hospital. So if my landlord is not providing me heat, and he's texting me about my rent, I ain't talking about my 3-year-old goddaughter being in the hospital. I'm talking about where's my heat. Unreasonable. You're not going to tell me, and it's absolutely her responsibility to call the city if she believes that the furnace is not working and the landlord is ignoring her request for heat. She never made a request for heat. That's the problem. She's been living in this house. There's no record, no evidence of any mold being brought before this court today. You knew you was coming to court. The evidence should have came with you. You knew you were alleging that there was no heat. There should have been some evidence. So look, Your Honor, here's a picture of my thermostat. My heat is running and it's not going up. You brought me nothing. You didn't even bring me proof of your electric bill to show me that it went up because of the fact that you've been running space heaters throughout a house to heat it. So you've not met any burden to show me, to make me believe anything to support your claim. To the contrary, the text messages make me believe that it wasn't an issue because you would be talking about that other than all the other things. Then what's really important to note is that after September 23rd, there's a text message in there. She's responded to every single text message about past due rent, and she's never on time. It's never happened. And then September 23rd, he tells her, I'm filing an eviction tomorrow if it's not paid. She said, I can drop something off tomorrow. And then she now brings up another issue about her car. Well, then we go into October, she goes silent. She says nothing. she didn't come to the court and file and escrow her rent and file a notice saying that I need you to force my landlord to give me heat. Nothing to operate or show operation in good faith. So for those reasons, I don't believe you have a lawful claim to withhold the rent. So judgment is in favor of the plaintiff in this matter.
Prepare the judgment if you'd like it.
Yes. Judgment in the amount of $7,900 for past due rent plus $167.28 for court costs for a total amount due $8,067.28. He'll pay that in full or vacate the property by the 24th of this month. There's also money judgment that will enter in the amount of $7,157.14 plus court costs. Grand total of the money judgment, $7,324. We'll get you a copy of that in just a moment. Any additional matters for the record? Mr. Jarwick, I'm gonna take my notes off and give you your exhibit back. Okay. Okay, let's see, Mr. Or Counsel, you ready on this bracket? No? I guess not. Let's see, Mr. Dua, did I see Mr. Dua? Not.
Yes, sir.
Oh, he's behind the computer.
Yeah.
Okay.
I'm ready on 8616 and 8617.
Okay, let's see, 310 Saginaw LLC versus Brandon Smith and Amanda Contreras, 24-08616. Appearance, please.
Thank you, Honor. Sam, do I hear on behalf of the plaintiff?
Please state your name for the record, please. Sir, what's your name?
Brandon Smith.
Okay, today was the date scheduled for a hearing for non-payment of rent. Counsel, how are you proceeding?
Thank you, Your Honor. I had an opportunity to meet with the defendants, and we have a consent order for conditional dismissal signed by both parties for your review. Rent in 2A, $2,295. Court costs $265.10. Total $2,560.10 for the period ending through February 28th, 2025. Box 3 is marked. Defendants are to pay $600 by February 24th and the balance by February 28th. 4B is marked, 7 is marked, and again, it is signed by all parties.
You can both stand, please. Okay, that's clear and accurate as to how you want to proceed?
Correct. Yes, ma'am.
Okay, and both of you have signed this?
Correct.
Yes, ma'am.
Okay, do you both understand that you have the right to be represented by an attorney in these matters?
Yes.
You want to give that right up?
Yes.
Yes, ma'am.
You have the right to proceed to a trial. You could have demanded a jury trial in this matter. You understood that, right?
Yes.
Do you want to give up your right to trial?
Yes, ma'am.
You also understand that partial performance of this agreement won't satisfy it. So if you don't perform fully as to what you're going to say, the amount you're going to say and how you're going to pay it, then what could happen is they could file a notice with the court that would insert a judgment against you without noticing you of any court date, and they could evict you from the property. You understand that?
Yes, ma'am.
You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights we just discussed, you can return to the court, request to have this set aside. We'll set it for a hearing. Otherwise, this matter will be dismissed upon the condition that you pay the amount of $2,295 plus $265.10 for a total $2,560.10 for rent due through the period of the 28th of February 2025, and you'll pay $600 by the 24th and the balance by the 28th. Get your copy in just a moment, okay? Thank you. You said 1/8, let's see. No, once, the fountain and then 1/7, you say you're.
Correct, yes.
Okay, this is 917 Seymour LLC versus Kirra Cox, 24-08617. Appearance, counsel.
Thank you, I understand. I'm doing here on behalf of the client.
Okay, and your name, ma'am?
Kirra Cox.
Okay. Who are you, sir?
It's my husband. I'm sorry.
Do you live on the property?
No.
Oh, okay, because his name's not on here.
Correct.
So you don't have to sit there then. You can sit back there unless you're a party. Okay, how are we proceeding?
Your Honor, I had an opportunity to meet with the defendant, and it's my understanding that the property has since been vacated and the landlord is in the process of attempting to re-let the apartment. This is a complaint for monetary damages, and I've exchanged information with the defendant and hopefully a chance to negotiate this later. If we could, I guess.
Reset it?
Yeah, reset it and sort of treat it as general civil, since possession is no longer an issue.
You filed for money damage?
Yes, sir.
Who needs a hearing? March 12th at 1:30. March 12th at 1:30. Is that enough time?
If it's not, I will do a stip in order. Yeah.
Okay, sounds good.
Thank you.
Do you have any questions? Okay, so we'll see you March 12th, 1:30, unless that date no longer works for the attorney, meaning he has a conflict or something with his court schedule. And he'll let us know, we'll get a new date. We'll get you a copy of the paperwork today, okay? If you all come to a resolution, you still have to put it on the record. And so you can log in for Zoom if that's the case, okay?
Okay.
Okay.
I'll be in touch with you because we've got some back and forth to do for sure.
Okay.
Thank you. Thanks.
Okay, have you seen your other matter yet?
I haven't thoroughly checked.
Oh, okay.
So I just want to make sure I check the hallway and all that.
Sounds good. Okay.
You're all set. Thank you.
Thank you.
Yep, I'll be in touch in a few days.
Have we seen Michael Gortarez? Okay, are we ready on that matter?
Yeah.
Okay, Pacific Flats versus Michael Gortarez, 24-08621, appearance, please.
Afternoon, Judge John Wilburn, P 83143 for plaintiff.
Okay, and then you're Michael Gutierrez without counsel, correct, sir? This is a non-payment of rent hearing. Did you resolve it at all?
We did, Your Honor. So Mr. Gortarez had indicated to me that he is actually vacated. However, keys had not been turned over. He did turn over keys to the property manager in the hall today. I just wanted to go on record to confirm that we can take possession and that any remaining property is deemed abandoned. I just wanted to make a record of that. We did not seek a money judgment in this one. So with that understanding, we will be dismissing the case.
Is that correct, sir?
Yes, Your Honor.
You didn't leave any of your stuff there?
No, I did. I told him, that's what the security, I'm not denying I left then. I'm not denying I left a month early. I just got a baby on the way. It's not really a good area. A lot of nasty stuff goes on over there, so I
Okay.
just had to better myself. I'm not denying that.
Okay, so you're gonna file a dismissal?
We will. And sir, just to confirm that you are abandoning any property left remaining, correct?
Yes, ma'am.
Okay. With that, Judge, I will submit a dismissal on the matter.
Thank you. You're all set.
Have a
Thanks,
blessed day.
Judge.
Thank
Have a
you.
good afternoon.
Have a good one.
Thank you. Have a good day.
I think we were waiting for Mr. Tyler, right?
He was here, they ran out.
And Brackett. Sabrina Brackett. Okay, on the record in the matter of Huntertown Properties versus Sabrina Brackett, 24-08. So forth, Council.
And the large tower of the applicant, P 86242.
Oh, so this is for non-payment of rent. Did you resolve this at all?
Yeah,
Oh,
we
yes, Your Honor.
have an agreement, Judge, it's a consent order for conditional dismissal, if you'd like, I can put it on the record.
Yes, please.
All right, the amount owed is $6,608.58. Cost is $191.04 for a deficit total of $799.62. And the terms in paragraph 3 are that defendant agrees to vacate the property located at 3021 Beaujardin Drive, apartment 107, Lansing, Michigan, either on or before February 27, 2025. She shall turn in her keys to the front office before the end of the day. I do have a proposed order collective approach.
Yes, please. Thank you.
You're welcome.
Okay, and then Mr. Turner, that's how your client wants to proceed.
Yes, ma'am.
Okay, ma'am, you understand that you have the right to proceed to trial in this matter?
Yes, ma'am.
Okay, you want to give up that right to trial? Okay, and the terms that you heard the attorney say, that's accurate as to your understanding?
Yes, ma'am.
Okay. You have 3 business days from today's date. If once you leave here, you realize you misunderstood the right that you've given up to enter into this conditional dismissal, you would need to return to the court within those 3 business days and file a motion to have this set aside, and we'll set it for hearing for you to explain how you misunderstood your rights. Lastly, partial performance will not satisfy this. So you said you're gonna pay $6,799.62 or vacate the property located at the address in question on or before February 27th and turn over the keys by the end of the day, okay?
Yes,
So you gotta do that. When you vacate the property, that means you're taking all your stuff.
Yes.
And you're turning over the keys. They gotta know that you're turning over the key. You can't just leave the key in there and expect that they know it, okay?
Yes, ma'am.
Do you have any questions for the court?
No, ma'am.
Okay, any additional matters for the record, counsel?
No, really good. Thank you.
Get your copy in just a moment.
Okay, thank you, appreciate it.
You're welcome. Let's see.
Yeah, you had fun.
Thank you, sir.
Yeah.
Fred and Louisa Black, who's here for Cox? Who's handling that, do we know? Oh, we just had Cox here on another matter. Did she leave?
Yes.
Yes, is she here for Cox? And then Mr. Dewey, you don't have anyone else here?
I do not.
Okay, you can submit default.
That is not mine. Madam Pro Chair.
Yes. Thank you.
Okay, most of it up. It's in my size.
They paid most of it up, it should be paid.
Right.
What did they get in this? That's for sure.
Or, no.
You mean the attorney that was just here? He just walked outside.
Oh, okay.
Are you waiting for a court date, ma'am?
I was here for
What's your name?
Patterson to find them.
Okay, I think I'm looking for the attorney. Whoever's here for Cox. She was just here on another matter, but I don't know what she wants.
Everybody.
Thank you. You don't have anybody here on the 330s out there? Megan?
I'm gonna go check.
For Mike?
Oh, not you.
Oh, okay.
You're
Scared.
done.
I finally got two of them.
Okay, on the record in the matter of Fred and Louisa flat versus Tequila Patterson. That's 24-08637. Appearance, please.
Jen Milburn, P 83143 for plaintiff.
Large tire P 862.
Let's see. Date to date set for hearing, you said you submitted a resolution.
We did, Your Honor, by way of conditional dismissal.
Hi, ma'am.
I agree.
Okay, you can have a seat. Okay, I have a conditional dismissal here. It says that the matter will be dismissed with the condition. It says past due rent is $1,289.08 plus court costs $188.79 for a total due $1,477.87. That's for rent due to what period?
Through February, Your Honor.
February 28th.
That's correct.
Okay, it says defendant agrees to pay rent by the 5th of each month, plus an additional $450 to be paid by the 3rd Friday of the month for the months of March, April, May, and additional of $127.87 plus rent in June to bring herself current, and plaintiff agrees to repair 2 broken windows on property either on or before April 30th, 2025. That's complete and accurate, correct?
That is correct, Your Honor.
Okay, and so I see signatures there. That's your understanding of how you want to proceed, ma'am?
Yes, ma'am.
You understand that you had the right to have a trial in this matter? Yes, ma'am. And you had the right to, well, you do have counsel in this matter. You want to waive your right to have a trial in this?
Yes, ma'am.
Okay, you understand that you have 3 business days from the date that this is signed, which is today, to return to the court if you realize you misunderstood the right that you just given up, which is your right to trial. You understand that?
Sure.
And partial performance of this agreement will not satisfy it. So you have some stipulations here or further conditions as to how you're going to make your payments. You have to follow that, ma'am. Otherwise, if you don't follow it, they can have judgment enter against you without having any further notice to you for a court hearing. You understand that?
Yes, ma'am.
You have any questions?
No.
Any additional matters for the record?
Nothing for me, Judge.
Okay, you're all set. Thank you. Okay, let me see.
I will be right back to that.
Let me sign it. You have any other matters? Well, you are.
I submitted a contempt judgment in that one.
Mark versus Patterson. Okay, this is the matter of Fred and Louisa Black versus Brianna Moore. Okay, 24-08636. Appearance, please.
Jen Wilbransky, 83143 for plaintiff.
Roger Tyler, P 86242. On behalf of the defendant.
Okay, there was a conditional dismissal in this one as well.
Consent
Consent
judgment.
Consent judgment. Okay, I do have a landlord tenant judgment here by consent. It states that the parties are entering judgment whereby the past due rent to retain possession is $6,055.60 plus cost of $188.79 for a total amount due $6,244.39, and that the tenant will pay that or vacate the property in question no later than the 28th of February. Is that completely accurate?
Yes, sir.
That is correct, Jen.
It also says that the parties agree to set aside judgment if the defendant vacates by the 28th. Said defendant's attorney to advise plaintiff's attorney. Accurate?
That is correct.
Okay. Ma'am, you understand that you had the right to proceed to trial in this matter? You want to give that right up? And you want to enter into consent judgment with the conditions that I just read?
Yes.
Anyone threatening you to do that? Any promises being made if you enter into this judgment? You have 3 business days from today's date. If once you leave here, you realize you misunderstood the right that you've given up, which is your right to trial, you can return to the court and request to have this set aside, okay? Is that a yes?
Yes, ma'am.
Okay, well, I'm signing this for today. Any additional matters for the record?
Nothing for me, Judge. Thank you.
Okay, you're all set. And then we just have one more race of let's.